of the province will be governed over the next 4 years by an irregularly appointed provincial leadership. And then it went on to deal with this. I just want to stress the analogy to say two things. One is that we know that when we're dealing with the preliminary issues, the court has to assume that we're correct on the merits. And that's why the court articulated like this. If it turns out that what is true, it didn't mean that it was true, but it had to be assumed. And secondly, it said for the whole time, the province would be governed by an illegal government, as it were. Same thing here. We're saying if it turns out that we're correct, then the rest of the commission will proceed on the basis of an illegality and a patent bias, if we're correct. And it said that paragraph 18, the appellants were denied the opportunity to have the merits of their application heard on the basis of technical procedural grounds. We have come to the conclusion that these grounds were incorrectly relied upon by the High Court, and then it went on to evaluate all of them. Then at paragraph 33, the court said that this would mean that this court would be the court of first and last instance as far as the merits are concerned. Although this consequence is unfortunate, it was, in my view, necessary to go through this route. And I might punctuate that by saying that the court in Ramakatsa, what it did to circumvent this problem was to ask both parties to supplement their papers so that this court would be able to deal with the merits more fully. In this case, that's not necessary because we have a full set of papers and the matters were fully canvassed in the previous court. Lastly, on that score, why I say this case is better than Ramakatsa with respect is that in that case, that was a single judge. Here we had a full court. In that case, we only had the views of the court on the technicalities per se. Here we do have, albeit in a minority judgment, the wisdom of the lower court on the merits. And on those bases, we say that the cases are similar, but this case has got much more commending itself for the procedural issues to be ruled in our favor. Then I move to what I call part 2, which is the legal issues that have been raised. I will race through quickly the other 3 so that we can then come to the main issue of Section 47. The one issue is that has been raised is that the application has been brought in medias res. In our respectful submission, there's no merit in this submission for the reasons that have been very well articulated by Mudiba J in her judgment, namely that this matter is not so much about the outcome than it is about the illegality of the process itself. In other words, irrespective of the outcome, whether it's good or bad or indifferent, the process itself would have been tainted by illegality, and therefore it's an exception to the rule. Secondly, in our respectful submission, this case, and this is linked to the exceptional circumstances around direct access and so on. This is a case where the exceptional circumstances, the serious nature and the legal implications of the matter, for both sides for that matter, speak for themselves. And therefore, even if one were to approach it from the test of grave injustice that was developed in cases such as Wallau's, in our respectful submission, both the test of exceptional circumstances and grave injustice, which would otherwise result, have been met. And therefore, this is a case where the court, with the greatest respect, would be enjoined to hear the matter. Again, on the basis that if we are correct, if the merits are correct, then we're dealing with quite an egregious kind of illegality. Then there's another issue of undue delay which has been raised. That issue should not detain the court much longer. Firstly, in respect of former President Zuma, in our respectful submission, there is no valid case to suggest that there was undue delay in the first place. Because on the facts, it's very clear that what had happened is that it's common cause that he was appraised of the rule, the notice, 3.3 notice at the beginning of October of the year, and he wrote a letter or caused his attorneys to write a letter to ask for an extension because he was out of the country, and that extension was thankfully granted by the commission. And once he was then able to consult with his attorneys, then he set the matter in motion in a nutshell. So there's no question of undue delay. But in the unlikely event that it can be found that that period of the couple of weeks until he instituted the recusal application was undue delay, we would say that this is again a matter that falls under that category of cases which were covered in the so-called Gijima principle, which was also confirmed in ASLA, where undue delay ought not to be allowed to shall we say, to cure an illegality, as it were. So, and that's what we say. Well, as far as President Mbeki is concerned, he obviously made suggestions that he was supporting our recusal application. And therefore, if our recusal application, excuse me, was not tainted by undue delay, then it is doubtful that his could be. But Mr. Maineche will speak to that. Then I will then go to the issue of the Rule 53(1)(b) application. This is a very important point, particularly for my applicant, because the court will remember this is where we insist, to put it mildly, that the allegations around the misconduct, alleged misconduct, or the the coaching allegations of the evidence leader, we submit very strongly that those allegations have not been properly met or denied by the commission. And if necessary, I'll go into that by using Plascon-Evans, various rules of evidence, including the fact that there's a duty to speak whenever there are serious allegations against you, which are peculiarly within your own knowledge. Those types of authorities from the rule of evidence, I'm sure the court is familiar with, is what we rely on for this proposition that there has not, in fact, it goes further than saying that there's not been a denial. We go as far as to say, in certain respects, there's actually been an admission of those facts. Now, why is that important? It's important because, as we all know, as lawyers, you can't effectively, the only way you can compel someone to discover something is that you must show that it exists in the first place. So if the existence, as it is in our version, is admitted or at best not denied, then the duty springs up immediately, the duty to disclose it. Lastly, on that point, we know that the only reason that the majority did not adjudicate that interlocutory application was on their version of the majority mootness. And that mootness, so that becomes it begs the question. The mootness, according to the majority, only arises because the Section 47 point is good. So we turn that argument around. If the Section 47 argument is not good, which we will submit it isn't, then the mootness reason for not adjudicating the Section 53(1)(b) falls away. And therefore that it will have to be confronted. That then leaves us with the again, I won't go through all the authorities. The court is familiar with the authorities, Helen Suzman Foundation, and those kinds of authorities about the fact that there's a duty on a party in a review application to discover every scrap of paper that may have any relevance to the topic. That it's a very wide duty. I'm quite sure the court will not question that proposition. The question, of course, is whether we have passed that threshold here. But as to the width of the duty, it is well accepted. I'm sure my learned friends will also accept it as such. That then takes us to the issue of the Section 47, which is the main issue that indisputably we're here about. On that issue, Justices, Deputy Chief Justice and Justices, we say the following. Again, the broad brush is that we obviously, unsurprisingly, align ourselves with the reasoning that is in the minority judgment. So that goes without saying. So I don't have to repeat what is in the minority judgment. But let me just break it down into a few constituent parts. In our respectful submission, that issue is an issue of interpretation. There's no doubt about that. It is, broadly speaking, deals with interpretation of the section, obviously, and interpretation of the plethora of high court cases that have dealt with that matter, and even in the interpretation, quote unquote, of the judgment, of the minority judgment, to the extent that we support that minority judgment. So let me break that into those constituent parts. Regarding the interpretation of the statute itself, the submissions we make are the following. Firstly, that that section, the purpose of that section has been mischaracterized both by the majority as well as those high court judgments on which it relies. In some instances, it has been a misreading of those authorities with respect. I say that with specific reference to the Mutata judgment, FUL versus Mutata, which I will deal with, which was the judgment of Mlambo JP, as it then was, in this division. And we juxtaposed that particular judgment with the judgment of Benenge JP in the case of NP versus LP, that was in the Eastern Cape. And then, of course, there's the so-called Mantashe-Memela debate, which we have to deal with, but we say that that debate, contrary to what is posed by the other side, is not decisive of the issues. It deals only with one of the issues that we raise. The main issues that we raise on interpretation come from the text of the section itself. One is the interpretation of the word judge in that matter, or if you like, the phrase judge of a superior court. Then there is the interpretation of civil proceedings. Are the civil proceedings that are referred to in that matter, do they fit these particular civil proceedings? And that is linked with the main reason why Modiba J found in our favor on this point. in the sense that the court will remember that what she essentially said was that these were essentially recusal proceedings, or akin to normal recusal proceedings, and that in those types of proceedings, then the judge is not even required to be cited in the first place. But secondly, that judge could not escape or be insulated, to use her word, insulated from scrutiny against bias by by Section 47. So that's the second phrase. The third phrase whose interpretation is important in the section is the head of that court. And in our respectful submission, that the head of that court indicates clearly that the section was not intended to deal with retired judges who perform non-judicial functions. And that issue of non-judicial functions is going to be important, so I'd like to underline that. And that is the purpose of all of this is to make the following points. One, that this section does not apply in this situation. Around the issue of retirement, which I've mentioned, but around the following also a very important issue. If a judge, retired or not retired, doesn't matter for the purposes of the second point, is cited in their non-judicial capacity, nomine officio, as was done in this case, then again, in our respectful submission, that the section doesn't apply. And I would say, speaking for the first applicant, because as the court knows, the second applicant joined our case, as it were, that if you go to paragraph 4 of the founding affidavit, you will see that there was a conscious decision to cite the chairperson of the commission in a particular way. And that citation, I'm paraphrasing, goes something like this. The third respondent, I think she is cited, no, it's the first one. She is cited is a retired judge and a former justice of the High Court. She is cited in her non-judicial capacity as the chairperson of the commission. And then it goes further. And we will strongly submit that that citation alone is a major differentiator. And that's why we say the Memela-Mantashe debate doesn't deal with all the issues, because it really deals with the first part, but not with the retirement issue. So those are two separate issues. Now, before I move away from this, I want to say the following. Apropos why, in our respectful submission, the judgments that were relied upon by the majority either A, were wrongly decided or misinterpreted. And this is something that really occupied our minds as to where is the actual nub of the problem. And we've come with this formulation with respect. There is a conflation on the meaning of the terms service, active service, or judicial service, rendering a service, and performing a judicial function. This is very crucial to this differentiation. How does this manifest itself, that conflation? In the cases where the two things are conflated, there are two cardinal mistakes that are made. One is very cardinal because it manifests itself in the transplantation, cut and paste, to use colloquial language, of a definition of something in one statute whose purpose is one thing, and literally transplanting that into another statute with a completely different purpose. You cannot do that. In the modern interpretation, whether you're talking about endumeni, cool ideas, and all those kinds of cases, the purpose is all important. So the purpose, the context, and the constitutional alignment, so to speak, are crucial in the interpretational exercise. So one of the worst things you can do in breach of that interpretation exercise is to go and mine a definition from something that was meant for something else and then put it, just plonk it and put it into something else that was meant for another thing. That's what we regard as the cardinal sin, and that seems to be at the base of this conflation. How does that do? Because what those cases do is to take the word service as used in the Remuneration of Judges Act and put it in the Superior Courts Act, Section 47, and then say, well, because in that act, it says that service, a judicial service, refers to, includes commissions of inquiry. Therefore, ipso facto, in Section 47, it means the same thing. There are two problems with that. Firstly, Section 47 doesn't say anything about judicial service. It refers to, it relates at least to judicial functions, which is a completely different matter altogether. Now, what is wrong with this transportation exercise is that it takes what is really a remuneration statute, something to do with the payment, and elevates it into a constitutional principle. What do we mean by that? The section to do with judicial functions is a matter that deals with what are the core functions of judges. And the court will be familiar with cases such as Heath, the South African personal injury lawyers versus Heath, where the issue of judicial functions was spelled out, and which in our respectful submission deals with sections of the Constitution such as Section 165, Section 176, which talks about active service and when such active service terminates. Contrary to Section 2195 of the Constitution, which really deals with remuneration of judges, public protectors, auditors general, and those kinds of people. So what we're saying is that a remuneration statute is now being used to interpret a statute that deals with the protection of judges to the extent that is. Secondly...
So, Advocate Nkofu,
yes,
the gong is gone.
I understand. I heard it. May I just wrap up this point, or unless if there are questions, which maybe the point will come through this, because I just wanted to highlight something as far as part 3 is concerned.
In 1 minute.
In 1 minute, yes. Now, when it comes to the third part, thank you, Deputy Chief Justice. When it comes to the third part, we'll make 3 quick points. The first one is that what we've termed the ultra-virus point. There is no world in which it can be justified that a decision taken by, or rather a matter that was heard by a panel of judges, of commissioners, whatever, is then decided by one of them. Whether you're talking about a full court or 3 commissioners, and as in this case. And the justifications that have been offered here, quite frankly, do not even withstand the first scrutiny. So the decision would be reviewable on that basis alone, that it was taken by one person when it was heard by the commission itself. One. Two, when it comes to the issue of actual bias, we have two grounds. One is the issue of the misconduct, alleged misconduct that I referred to, and the second one is the issue of what we call the media campaign. The media campaign that was conducted by the former justice regarding, in particular, Mr. Zuma, where she went and had interviews in the media, more than one at least, about why she found this way or that way in a case where she was sitting. That's not done. There's not even a debate. Everybody knows that that is not done. Doesn't matter how strongly you feel about the judgment. You can't just go to ENCA or whatever and say, no, you know why I found that way was because one of the reasons why we protect judges so much against unfair criticism is exactly because they are helpless. They can't, I can go and say all sorts of things about the judge, but the judge is not in a position to say, okay, well, I want my own interview, and that is for a particular reason.
Yeah.
It's
I will stop you there.
Yes, in fact, the last point, which is the reasonable apprehension of bias, I'm not going to deal with because Mr. Manage is going to deal with.
Okay.
Thank you so much, TCJ, for the indulgence.
Thank you very much, Advocate Mpofu.
Mr. Mpofu,
Justice Mhlanga.
I'm interested in the interpretation of Section 47.
As a copy.
In particular, if you look at the section, it's broad. It does not make a distinction between an active judge and a retired judge.
Yes.
So why should we then narrow it to only deal with active and exclude a retired judge? Why should it be the case?
Yes. Yes. Thank you, Justice Mhlanga. As a separate point from the citation point, specifically the retirement issue. Yes. In our respectful submission, Justice Mhlanga, it is as follows. If you analyze the reasoning of Mbenenga JP, he makes it very clear. Firstly, purpose, we all know, purpose is important. And that's where we say the disconnect happens. The purpose of the section is not, as the other side would suggest, the primary purpose, at least, is not to protect the independence of the judiciary and all those lofty ideals. It might well be that that's one of the purposes. But the primary purpose of this section is to ensure, as was articulated by the DCJ in his previous incarnation. The primary purpose is to ensure the smooth running of the courts. It is to ensure that there's not chaos, where a judge is allocated by the head of court, and then it turns out that he has to go or she has to go and appear in some matter. So that's in our respectful submission, the primary purpose is less ambitious than all these other issues. That is not to say those issues are not important. Remember, the issues of the independence of the judiciary are sufficiently protected by contempt laws, by immunity laws, and so on. The narrow purpose of this particular section is to ensure that the judiciary runs smoothly. Now, if you accept that for a minute, Justice Mhlanga, then it will follow that unless, and this was a very important point made by Justice Mlambo in the Mutata case, that of course retired judges may sometimes be called upon to perform judicial functions. In that case, they are definitely covered. We accept that. But that must be distinguished from retired judges who are performing non-judicial functions. Because when they are performing non-judicial functions, Section 47 is not intended to protect them. And this formulation was made very clear by Justice Mlambo in the Mutata case. Sorry. That's case number, oh, sorry, we didn't upload these cases, so we'll for my colleagues in the bundle, it's page 761 onwards. But this is what Judge Mlambo said at paragraph 23 of Mutata, apropos this distinction I'm making. And what he was saying, he was commenting on the Mbenenge JP formulation, basically to say it's not a blanket thing of are you retired or not retired. It's a question of what are you actually doing, which we agree with. And he said at paragraph 23, or at 22, at the outset I point out that the absence of both the old and new sections of a distinction between judges still in active service and retired judges is not insignificant. Perhaps the most obvious reason is that judges' appointment is a lifetime appointment. It subsists even during the time when the judge has retired. However, for a more fundamental reason of the statement, that retired judges no longer feature in the running of the courts, which is the important thing, must be qualified as I do below. He went on to say, we know that there are judges who retire, but who continue to feature in judicial functions and activities. Very, very important. In other words, the judges who might retire, but are not just sitting in farming somewhere, but are called upon to continue to perform judicial functions. And this is to finalize the part-head matters seized with by importantly retired judges appointed to undertake judicial activities despite being retired. And then he goes on. And then he said, retired judges who are called to act from time to time or to finalize part-head matters fall within the ambit of the above-mentioned administration in that the head of the court retains supervisory authority over retired judges. This is the most crucial point. Those judges, retired or whatever, once they are called back, the head of the court retains supervisory authority, and therefore they are obviously hit by the section. And then I'll jump to paragraph 24, and where the learned judge said, judges who are retired but who continue to either perform judicial functions when called upon to do so by the minister, in line with D, have been appointed to perform the other function as provided by the section. So we agree with that formulation. Where we part ways with the Mlambo JP as it then was, is when he then, from that point, he then commits what we call the cardinal mistake of conflating judicial functions with service, as in the Remuneration Act. That we, in our respectful submission, actually counteracts the excellent distinction that he made between a retired judge who is called upon to do a judicial function and then any other retired judge. And then to bring it home to this case, what we're saying is that the judge, the retired judge in this case, was not called upon to perform a judicial function. In fact, she was called upon to discharge an administrative function, advisory to the president, an executive function for that matter, which is certainly not a judicial function. Thank you.
The commission, is it not called a judicial commission?
Yeah.
So,
Yes.
and the judge, what is the judge supposed to be doing?
Yes. No,
The
that,
retired judge there.
yes, no, thank you. No, there's no such thing. You see, the thing about judicial commission is just talk. There's no such thing as a judicial commission of inquiry. If you go to section 84(2)(f) of the Constitution, it says that the president is empowered to appoint commissions of inquiry. So just because in our everyday language we say it's a judicial Commission of Inquiry does not make it such. It doesn't make this Commission of Inquiry, Judicial Commission, more than the TRC was a religious Commission of Inquiry because it was chaired by a priest. So those adjectives that are used in qualifying the Commission of Inquiry are merely, as I say, just everyday language. But strictly speaking, Justice Mhlanhla, a Commission of Inquiry is a Commission of Inquiry. And therefore, and to illustrate that point, Justice Mhlanhla, let's take 3 commissions. Some of the well-known ones. I've already mentioned the TRC, and then there was the all-important Muarane Commission, which brought us the PKTT and all the things that have subsequently happened. And then there's this commission, or let's take either the so-called Zondo Commission or this one. Those 3 commissions, Justice Mhlanhla, are commissions of inquiry in the same way. They were appointed by the President in terms of Section 84. And it cannot be that simply because one of them is chaired by a judge, then there are certain protections which would not apply to Archbishop Tutu or to Muarane SC when they are doing exactly the same thing, appointed by exactly the same person to do exactly the same job. So that's a distinction that is just artificial with respect. Thank you.
Still on this provision,
Yes.
it says no civil proceedings by way of summons or notice of motion may be instituted against a judge.
Yes.
A review, what is a review? Is it not a civil proceeding?
Yes, it is. Of course, it is.
So why would it be excluded from this provision?
Yes. Now, that's a separate point. Firstly, we deal with the issue of the judge. Is the person a judge or not, which you and I have just exchanged with. So if we're good on that, then it falls away. But if we are not, then on the point of civil proceedings, we align ourselves fully, as I've indicated, with the reasoning of Justice Mudiba, who says, in a nutshell, Justice Mhlanhla, that form cannot prevail over substance. In substance, what we have here is nothing different from a recusal application. The only difference really is this. If it was in court and I wanted Justice Mhlanhla to recuse herself, I would make that application to yourself with respect, Justice Mhlanhla, sitting in court. If you found against me, I would then appeal. At no point am I required to cite the judge that is being recused. What happens here is that for technical reasons which are not important, the recusal application is now brought in the administrative body. And when you can't appeal, there's no appeal in that. So if you are aggrieved by that, your remedy is to review, which is what we have done. So why would, she argues, Justice Mudiba, why would that in substance then be different? And suddenly the one is regarded as falling under Section 47, but the other situation, which is exactly the same, is not. So that's the first argument. The second is that she says that the difference between the appeal and review in this particular context is neither here nor there. The point of the matter is that the requirement, this is now me speaking, the requirement to cite a chairperson of an administrative body, as you know, Justice Mhlanhla, comes from Rule 53. Remember, Rule 53 says, when you are citing a body, whatever body, it could be the transport board or whatever, you cite the chairperson of that body. So as a representative of that body, here it happens to be the chairperson of this commission who is cited in that capacity. Very important. That's the nomine officio argument. Not being cited as a judge, not being cited even as the decision maker, not even being cited as the person who's supposed to recuse herself and all that, but purely on the basis that a decision of the body that she is chairing is being challenged in court. So why would you now suddenly say that, to go back to my previous example, if I was challenging the decision of Morane SC as chairperson, I could just do it. But when I'm challenging the decision of another chairperson in terms of Rule 53, I must suddenly have to do something different. So that's another distinction. Thank you, Justice.
At this stage, my last one, I just want to, it's an observation. If one looks at the section, as I said initially, it's broad.
Yes, it
and
is.
you seem to be seeking to narrow the provision. And I'm not sure whether we can do that on our own, or aren't we now going to be moving to the realm of legislating if we do that? That's my last one for now.
Yes, thank you. Well, in my respectful submission, you'll be doing that if you do the opposite. You'll be actually widening the section much wider. Remember what I said about this primary purpose. It should never be widened beyond its primary purpose to now suddenly become the one big protection mechanism for the judiciary outside of contempt proceedings, outside of all these. Its purpose in that context, Justice Mhlahla, is indeed narrower. And for an example, if you go to section 176, I think, of the Constitution, that section, 176.2, it makes a clear distinction between, we all know, and again, this is another colloquialism, that the appointment to a judge is a judge for life. No quibble with that. And that is why, for the purposes of remuneration, that has to be made clear in the Remuneration of Judges Act. So what the Remuneration of Judges Act does, Justice Mhlahla, is to say, let's call it, it's a deeming provision. So if a judge, retired, is appointed to chair a commission, that act basically says they're not going to get any extra pay or remuneration like I or my other learned friends sitting here would, because that's deemed for the purposes of that act to be still a service, continuing with the service. That's fine. We all know that's what happens. But that doesn't mean that the judicial office itself survives retirement. It doesn't. And the proof of that is it's 176.2, which says a constitutional court judge, sorry, I'm starting from 1. A constitutional court judge holds the office for a non-renewable term of 12 years or until she attains the age of 70, whichever occurs first, and so on. And then 2, which is the important one. Other judges hold office until they are discharged from active service in terms of an act of parliament. In fact, so what that means is that other judges hold the office in the broader sense until the date of their retirement. Right? Now, that makes it very clear. We're now dealing here with the question of the judicial office itself. If you go to 2195, it says something else. It says the remuneration of these offices, and then it lists them, will be dealt with. 2195, you'll find, it says, Justice Mhlahla, quickly. National legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, and members of any commission provided for in this constitution. And I dare say that the commission, much as I would have wanted to take advantage of that, but I don't I don't submit that that was meant, this type of commission. I think they meant like a commission for gender equality and so on. Including the Broadcasting Authority, that's ICASA, referred to in section 192. So all I'm saying is that we can have the same constitution, we mustn't conflate remuneration matters a statute that is meant to regulate remuneration matters with a statute that is meant to regulate something else. And that's the danger, with the greatest respect, with this, what I've called the cardinal sin. The definition section of a statute is not a dictionary. So you can't just say, okay, well, it's defined here as this, and therefore all forever, amen, it will mean that. Because that definition section was meant for that particular purpose and that particular context, all the issues set in cool ideas, and in paragraph 18 of Ndomain in particular, says that when you're doing this, the modern form of interpretation, you must emphasize the purpose, context, text, and all the things that we talk about. Thank you.
Thank you, CJ.
Thank you. Advocate Mpofu, just a quick one
Yes, thank you.
to clarify. You're saying chairing a commission does not come under the ambit of Section 47.
Yes,
So a judge who is in active service, who has not retired, who chairs a commission, also does not enjoy Section
it's not
47.
performing a judicial function, 100%. That's why
Who
I
does
said,
the same thing?
absolutely.
Okay.
Yes, absolutely, Justice.
No,
Thank you.
I wanted that. I don't want you to explain. I
No,
just wanted
thank
to
you.
clarify that
Thank you.
part.
No, that's why you remember when I said this, I said when we deal with this, whether the judge is retired or not retired, the point is that they are not performing a judicial function.
Yes.
And that you will find in Heath in particular. In Heath, they make the specific example. They say when a judge is chairing a commission of inquiry, they are doing an executive job. I'm putting it in my own language broadly. But they are certainly not performing a judicial function. That's one thing. Otherwise, separation of powers, all the issues that were raised in Heath would go away. In Amabungane, in all those kinds of cases, the same thing, where there was a so-called designated judge. There's no doubt that that judge is a judge, but whether retired or not retired, but they are not performing a judicial function, because a judicial function and an executive function are two different kettles of fish. And
So the same judge who is still in active service, who chairs a commission, and you ask for that judge's recusal, and the judge refuses, that decision will be subject to review, not appeal.
absolutely. It would be
Which is what
because
you argued earlier, to say in an ordinary matter,
yes.
where you ask a judge to recuse himself or herself, and he says, no, you appeal it. You appeal
No, so-
when he's hearing a matter, not a
Understand.
commission.
Understand the question, Justice.
That's what you said, isn't
Yes,
it?
that's what I said, but
Yeah.
what I said earlier
Yes.
must not be forgotten. Remember, when I was talking about the definitions, I said the first definition we must go for is judge. Is somebody sitting in the chairing a commission of inquiry or some investigation?
Advocate Mpofu, I don't want you to go.
No.
I just want to explain what my question is.
No, but it's very important, Justice, please.
Okay.
It's important to make this distinction. Because the mistake, with the greatest respect, that you make is to say, well, it's a judge. A judge is but I've already said that that person is not a judge for the purposes of chairing that. That could be Mr. Morane or someone else. But they're not performing a judicial function. The fact that they have a security of tenure for the rest of their lives as judges is known. But at that point, you are not citing them as a judge within the meaning of Section 47. That's
Thank you.
really the point. Thank you.
Good morning, Mr. Mpofu.
Good morning, Justice.
I have a question that follows on Justice Mtlantla's question on Section 47.
Yes, Justice Machi.
But also my primary difficulty is with an antecedent process of direct appeal to this court. So to make things flow smoothly, I'm starting with Section 47. That's backwards, but you understand why I'm doing that. I'm going to give you a hypothesis, and it's a hypothesis which is not too far from actually happening. Let's say I'm on long leave now until the end of the year, and then I retire.
Right.
So you got a period from now until, say, December 31, long leave, active service and then retirement. I'm also on the Judicial Conduct Committee. Now I sit in a matter, let's say a Section 17 matter where the judge may be cautioned or not discharged, that's impeachment, cautioned or fined or so on. I sit as a member of the Judicial Conduct Committee. You accept that if a matter arises in the course of those proceedings in the JCC, where there's some suggestion of impropriety, let's call it bias, whether actual or perceived, some things get that happen that get one of the parties thinking this may be a ground for recusal, but they're not sure yet. Then I retire, and that matter is parted, and I continue as a matter of the as a member of the Judicial Conduct Committee. But I'm now retired, and then more evidence comes to the fore, and the party is now absolutely convinced that there are grounds for a recusal application. Does that mean, on your argument, that up until December 31, if you would bring a recusal application, with enough facts at your disposal, you would need the consent of the head of the court, of the Chief Justice, because I'm a member of this court, and after that you don't need it?
No. That argument actually shows the absurdity of the counter-argument. Thank you, Justice Machit. Let me answer it like this. If that were the case, really imagine that. If exactly you're doing the very same thing, but merely by the fact that at a certain point you have retired, suddenly you now require a permission. That would actually be an absurdity, because it would in one way mean that when you were a judge, in the proper sense of the word, one did not need, and you are sitting, and I know I'm adjusting your example, but let's say if you're a judge sitting doing a proper judicial function, then I don't need to do anything. But once you retire, I suddenly have to get permission. But to come back to your specific example, the answer is still no, and it is no for the following reasons. Whether you are retired or not retired at a particular point, it's not about that. It's about the function that you are performing. That's really the issue. And that's where the nub of the confusion really arises. Are you performing a judicial function, yes or no? Retired or not retired? If you are, then the section applies, as was eloquently distinguished by Justice Mlambo in the previous matter. But Judge Mbelenge says that this provision is for the smooth running of the courts, and that is why the head of the court is the one who must give the consent. It is not it's not even a jurisdiction provision, as was wrongly suggested by the majority. It is because the jurisdiction of the High Court with respect is spelled out in section 169 of the Constitution. And that jurisdiction is either there or it's not there. And so the jurisdiction of the High Court is there. What section 47 does is something less majestic than confer a jurisdiction or otherwise. It simply regulates the functioning of the court, which is not an unimportant thing. We're not trivializing that function, but we're saying it must not be conflated with the broader protections of the judiciary, which we all support as court president.
Thank you. Now, can I just say that, I mean, sorry, were you finished, Mr. Mpopo?
No, I was, no, it's my fault, but I just wanted to make a certain point, if you allow me, Justice. This distinction, ironically, is made by Justice Khampepe herself. If I may just find the note, please, Justice. At 001-274, Justice Khampepe, who now comes, before the clever lawyers came to bring this Section 47 point, she herself stated in January, this point was brought in March this year. In January, this is what she said to show that she understood the distinction. Look at paragraph 38 and 39. She says, in giving her, Mpofu SC, who appeared for the former President Zuma, sought to downplay the judicial presumption of impartiality by arguing that I'm simply the chairperson of a tribunal and not sitting as a judge. I disagree. I've been appointed by the President through Section 82F presidential powers to chair a judicial commission of inquiry. We've addressed that with Justice Mkhandla, but the word judicial really doesn't add anything to that. I've been appointed precisely because of my oath of office and because I'm a judge, albeit presently retired. It is my considered view that Mpofu's contention is devoid of substance. The presumption of judicial impartiality remains in my present role as chairperson of this commission, as I've said, as the one not easy to dislodge. Now, she may be right or wrong about the presumption of impartiality. I'm just addressing your question. Now, here's the kicker. Paragraph 39. She says, this is not to say that I fulfill judicial functions in my present position. Commissions of inquiry are not courts of law. This commission is an investigatory body tasked with investigating the matters set out in these terms of reference. Commissions will ultimately report to the President, which means they are executive instruments, not judicial ones. On the outcome of those investigations, the Commission may make a recommendation to the President, but it will be up to the President on whether to implement such recommendations and so on. Now, here she's explaining our case, that although I may have been appointed because of my oath of office and the judicial impartiality, but I'm not performing a judicial function. Why? Because this is not a court. There's no Section 47 which can transform a commission of inquiry into a court. That would be a travesty of justice if the pun is excused. Because what she's saying there, paragraph 39, was correct, as I say, until such time. Or paragraph, I'm asked to read paragraph 40 as well. She says, at 40, this commission does not function as an adversarial body, and the proceedings before it must not be confused with litigious court-based proceedings with winners and losers. Correct. All I can say is we agree. We agree that she's not performing a judicial function, and if she's not performing a judicial function, whether she's paid or not is another matter, but she's not performing a judicial function. And if she's not performing a judicial function, Section 47 cannot apply. And as I say, subsequently, some clever lawyering came into the picture, and now the position was that, no, she was now performing a judicial function of Section 47.
Yes, thank you.
Thank you.
With great respect to my colleague, she's a formidable judge, but that's just an opinion.
Of course.
It's this court to decide. It's no different than the President coming here and saying, if I had known now what I had known then, I wouldn't have appointed her because of X, Y, Z. It's just an opinion.
Yeah, well,
I say that with respect. But let me move on. You see, Mr. Mpofu, I must say that there are strong arguments, and you've presented some of them very ably.
Thank you.
As to why this section could be interpreted both ways. But I've got an anterior problem.
Yes.
Antecedent problem. It's this. There is an appeal now pending in the Mantashe case, which is directly relied on by the majority in this case,
Yes.
before the SCA. It will be heard this year. You filed conditional applications for leave to appeal. You filed an application for leave to appeal in this court. You filed conditional applications for leave to appeal in the SCA. Now, why should the SCA not on an expedited basis hear those cases and you join the other case because they're the same principles?
Yes.
And I'll tell you why I ask this. If, as I think the Kalata group, the sixth respondent makes the point, if you're going to ask for a case management meeting in the SCA for the President or whoever judge is designated, to expedite this hearing because of the urgency of it, then this matter could conceivably still come before this court before the end of the year from the SCA. You see, in this court, I see you look skeptical, but you see in this court, we've got to be careful because, as you know, litigants come here in future and say, but you know, you did it in the Zuma matter, you heard a direct appeal, while there are appeal pending on the very, very same issues.
Yes.
So it does concern us. We, as you know, prefer to hear the views of not only the High Court, but also of the SA.
Thank you. Thank you, Justice Machid. Forgive me for the skepticism is very well justified and based on experience. That the chances of the matter coming here within and the commission being finalized in December on the extended are very narrow indeed. But
No faith in us or in the SA.
well, it depends where I'm standing. Right now, I'll say the SCA. Honestly, that's not Justice Machid. To take that route, firstly, let me say this. The only reason why we do the conditional application, as the court knows, is because it's just a question of time. Because if you don't do the conditional application and this court rejects the application, then you have missed your 15 days for application for leave in the High Court. So it's purely a practical reason. That's number one. Number two, the burden, let me put it that way, on us to make an intervention application in another matter where that intervention application may or may not succeed in the first place, as opposed to dealing with this concrete matter that is here now before us, is a risk that no party should be asked to assume easily. Thirdly, as matters currently stand, the main Mantasha matter, if I may call it that, is not being pursued on an expedited basis. And therefore, we cannot very well enforce or put down the throat of those parties expedition. Now, and I accept, Justice Machid, the reluctance of this court, which we all support, to hear matters as matters of first instance. And that is why I referred this court to paragraph 33 of Ramakasa, where that was done, reluctantly as it was, because of the other factors that we have relied on, and in other subsequent cases. Because, as I read out those extracts, I think it's paragraph 16, 17, and 33 of Ramakasa. And we, with the greatest respect, we say those considerations apply with equal force, if not more, in this particular case.
Well, lastly then, and relatedly, if you come to us to decide the merits of the review, then you're really coming on a direct access basis.
Yes, thank you. That is why both applicants have specifically asked not just for direct appeal, but also for direct access. Because you're right, in these kinds of situations, as was done in Ramakata, the direct access and the direct appeal was really on both legs, so to speak. And that is why I referred to what was then done in Ramakata, was to say, because the matter is urgent and it can't wait, it can't go through the whole route of SCA and so on, we are giving you parties, and I remember this because we were given like a week, to supplement your papers if you wish to, and then we'll hear the merits as well. And my response was that in this particular matter, that would not be necessary because the matter was extensively pleaded, extensively argued, and in the previous court. And more than that, we now have a bonus of the minority judgment, which has dealt with the merits. So to the extent that one wants wisdom of other courts, the wisdom is everywhere. We have the wisdom of the Eastern Cape, the wisdom of the Limpopo court, the wisdom of the Gauteng, the many Gauteng judgments that have been referred to, the wisdom of the Mantashe and Memela. So there's no shortage of wisdom. Even Erasmus says that on the question of retirement, I made a note of this. Erasmus says that it says there's differences of opinion on this question of retirement, and it cites the FUL case and then the Mbenenge JP case. So in our respectful submission, this is a case which commends itself for decision by this court. For an extra reason, Justice Majid, that these commissions, as we all know, are now proliferate. And these kinds of matters are brought in, day out, because of the Zondo Commission, the Matlanga Commission, and other commissions like that. And this point is being taken left, right, and center. And it is important that on our submission, what is purely a legal point, which is the interpretation of Section 47, should now be decisively, once and for all, put out there as the court places.
And do you accept that, lastly, on this point, that direct access is really a higher threshold to cross than direct appeal?
We accept that implicitly, that it is a high threshold, but again, we say exceptional circumstances, interests of justice, and the urgency of the matter necessitate, in the same way or even more, with bigger magnitude than in the Ramakatsa instance, that this case, this type of matter must now be put to bed. Because with the greatest respect, Justice Majid, to expect these parties who were the, shall we say, it would be almost like condoning the breach of the rule against piecemeal litigation. Because as we all know, and we've cited the authorities, courts, it is exactly because of the question you're posing to me, Justice Majid, that courts are told day in and day out that even if you find on a technical basis, on jurisdiction or whatever, you must still deal with the merits. Why? So that when we come here, we wouldn't be faced with a situation, imagine if there was no minority judgment. All we would be, this court, it would be unfair on this court, to be honest. All this court would be armed with would have been this interpretation of Section 47. And let's assume the court would then agree with us. It would then have to remit the matter, even worse than the SCA, remit it to the High Court, go to the SCA, and then come back here in 3 or 4 years' time. On these facts, there's simply no...
Ms. Peterson-Jones and Mr. Butlander will argue that you started all of this by bringing an application for review in midstream.
Yes, well, no, we didn't start all of this. The person who started this was the chairperson who remember, for this leg, we are assuming that our allegations are true. So we had a chairperson who, knowing that she had taken part in the decisions in the TRC and in the NPA, persisted unreasonably and illegally, if I may put it that strongly, to sit. She started it. We have a chairperson who was told by the president, who appointed her, that if I had known this, I wouldn't have appointed you, please go. She didn't go. She started it. We have a chairperson who has insisted on sitting in a position where she is, quite frankly, unwelcome, and her findings are bound to be found illegal. Because anybody, whether she finds for or against a person, is going to simply say, well, the person who appointed you said they don't want your advice. Remember, commissions of inquiry are advisors. They're in the same position as a DG. So you can't force yourself, just like me. If I go to a client and I say, the client says, please advise me on this, Mr. Mpofu, and then I give the advice, and one day they say, I no longer want your advice. But I can't say, no, you want my advice. I'm going to give it to you whether you like it or not.
Yeah, I just want to say on this, this is the merits, I'll leave it for my colleagues who want to pursue it, but it just seems to me that when you are asked to do a commission of inquiry on one aspect and one aspect only, is to investigate whether these allegations of political interference in the work of the commission is true or not. I fail to see, prima facie, you can persuade me otherwise, of course, how that links to your work in the TRC Amnesty Committee and in the NPA.
Yes.
That will be my last question.
Thank you, Justice Majid. Let me assist then very quickly. If Justice Majid, let me put it this way. On the facts of this case, you have a person who sat in the amnesty committee of the TRC to decide who should be prosecuted and who should not be prosecuted. That person, and my learned friend Mr. Manager will refer you to the specific findings which are signed, Justice Khampepe. They have to do with the PEPCO 3 and a gentleman family of Mutasi. Those people are members of the Kalata group. So you have the same person who denied the amnesty to make those people prosecutable. After that, she then moves to the NPA. In the NPA, what does she do? She works for something called the HRIU, whose function, according to Justice Saldanha, is to investigate the prosecution or non-prosecution of those people that she denied investigation. That alone was illegal, if you ask me. But then it doesn't stop there. Now, this is triple bias, if there's such a thing. She now sits to judge whether the NPA and the Amnesty Commission, that chain, was suffering from political interference. And that political interference would have been, if it was there, meted out to her, because she was the Deputy National Director of Public Prosecutions. How on earth can that person, of all the judges in this country, be the one to investigate this? I can tell you now, Justice Majid, that there are maybe let's say two for argument's sake. Two people who should not be chairing that commission. One of them is Justice Saldanha, and the other one is Justice Khampepe. Why? Because Justice Saldanha was called recently as a witness in this commission to deal with exactly this point of when he was sitting with Justice Khampepe in the HRIU, whether they influenced or not. Mr. Nguka, who was their boss, both of them, has been called as a witness. So that means that Justice Khampepe is a competent and compellable witness in the commission that she's chairing. What is that? That can never be countenanced in a democracy.
Deputy Chief
Thank you.
Justice.
Thank you.
Thank you, Mr. Mpofu.
Sorry, Justice Khalapa.
Mr. Mpofu, it's common cause that we're not dealing with a constitutional challenge to Section 47,
Absolutely. No.
but rather its proper interpretation.
Correct.
You point out that both the majority and the minority judgments in the High Court did not address the interpretation of Section 47. Well, your heads of argument say that. But anyway, that's not the heart of my question. What you're really saying is that we should properly interpret Section 47.
Yes, the minority did on our version. Yes.
Based on that, we need to start with the plain language of the section and have regard to both the context and the purpose.
Correct.
You point out that the purpose of Section 47 is to ensure the smooth functioning of the courts. Is that right?
Correct.
And
the
we have
primary, what I call the primary purpose.
Sorry?
What I call the primary purpose.
The primary purpose.
Yes.
And we have to then interpret it in accordance with that purpose.
Correct.
Now, if one has regard to the structure of 47, it's broken up into two parts.
Yes.
The first part provides for the consent of the head of court, correct?
Yes.
The second part deals with ensuring that there's consultation with the head of court when a judge's attendance might be required in proceedings.
Yes.
It says so expressly,
47.2. Yes.
47.2.
Correct.
It must be determined in consultation with the relevant head of court. That is when a judge is required to attend court.
Yes.
It would seem to me that 47.2 is primarily concerned about the smooth functioning of the court, because you would need to consult with the head of the court in order to ensure that the court is not disrupted when that judge is required to attend proceedings.
Correct.
So having regard to the basic canons of interpretation that we all agree upon. Why was there a need to have 47.1 when the primary purpose of Section 47 was to ensure the smooth functioning of the court, and 47.2 does that? All that the legislature would have been required to do was simply say, when a judge is sued, then the head of court must be consulted when that judge is required to attend court. If we read 47 on the consent part, in accordance with your understanding of purpose, then we give it a meaning that's wholly different from the purpose you say, and therefore it must raise in the sharpest terms whether the purpose you ascribe to the section is consistent with the terms of the section.
Yes, thank you, Justice Kalopen. Yes, I understand the question. The first answer is this. The purpose of Section 47 is the purpose of Section 47. It doesn't have one purpose in subsection 1 and another purpose in subsection 2 as such. I accept that, as you correctly point out, that the two subsections deal with two separate situations. But that's not a question of purpose and context. The purpose, the context, the constitutional architecture of the section remains what it is. And with the greatest respect, that purpose is even traceable to the, I think it's Section 8 of the Superior Courts Act, which deals with this thing about judicial functions and so on. Now, we say, in a direct answer to your question, Justice Kwalapen, that those two purposes or those two subsections serve effectively the same purpose, which is the smooth running of the courts. And we agree in that respect with Justice Mbenenge, and we agree in that respect with Justice Mlambo, up to the point that I said we agree, if you put away this thing about the service coming from another act and so on, that section applies to retired judges who are called upon to perform judicial functions from time to time, whether it's acting and so on. Why? Why does it apply to them when they do that and not when they are farming somewhere? It is because the purpose is the regulation of the courts. The minute they get involved in that business of the smooth running of the courts.
I understand that, and sorry
Yes.
to interrupt you, but my difficulty is that if that's the purpose, then a reframed 47.2 would achieve that purpose. There is no need to obtain the consent of the judge president if the mere issuing of a summons is not going to disrupt the functioning of the court. Surely a summons that's issued today in the High Court will only get to trial in 3 years' time. The issuing of that summons can't disrupt the functioning of the court. Why is the consent of the head of court necessary if, according to you,
Yes.
it's to avoid the disruption of the court's functioning?
Yes, thank you, Justice Kalopen. The point I'm making is that both sections deal with the permission of the head of the court. The other one really is...
They don't deal with permission. The first one deals with permission. The other one is really a consultation so that you negotiate a time.
Well...
Yeah. But I mean, the first one is a condition precedent, not so.
Fair enough,
Yeah.
fair enough. But the point I'm saying is that both, I'm not saying consultation and consent are the same thing. I'm saying both deal with the smooth running of the court. Both the consent requirement and the consultation requirement in 47.2. I accept that they deal with two different topics, but I'm saying both topics have to do with the smooth running of the courts. And if you look at, it says where the issuing of a summons or subpoena against a judge to appear in civil action has been consented to. In other words, when one has been dealt with, the date upon which such judge must attend must be determined in consultation. So this is just about now the date, the practical arrangement of whether having received this consent to further protect, if you like, the smooth running of the court. You can't simply say, oh, well, the head of court gave me permission, so I'm now going to just somewhere call that judge on any day that I like. You must still, to protect the smooth running of the court, do the consultation. Thank you.
Thanks, Mr. Mpofu. I take a different view because I see them doing different things, but
No, they
we-
certainly do.
we need not exhaust them because, as I point out, I fail to see how the issuing of a summons can affect the smooth running of a court. It may potentially affect that when you have to come to court. But let's move on to the second concern I have, and it's this: the capacity in which the question of capacity, according to you, is whether you were a judge in active service or you were acting at the time, having been discharged, where consent is required. Correct? I mean, if you were
Yes,
discharged,
yes,
and
yes,
if you're
yes.
discharged and you're
Yes.
asked to come back and act, then
Yes, that's part of it, Justice Kholopin. And the citation, the capacity in which you were cited. But I'll go along with that.
Okay.
Yeah.
But can I just get the capacity in which you're cited?
Yes.
Are you saying that a judge who's in active service and who's sued for defamation, let's say, in respect of a private matter, that has nothing to do with judicial proceedings in which that judge presided, Section 47 would kick in, not so? I mean, if today you want to sue a High Court judge for having defamed you in a public place,
Yes.
you would need to comply with 47, not so?
An active judge.
Yeah.
Judge in active service.
Judges, you would need to.
Yes, because,
So your
but that's for a different reason.
yeah, but your capacity in which, in relation to the lawsuit, doesn't really matter, because you were acting in your private capacity when you defamed somebody, but you're being sued, and the person who's being sued is a judge. You're not being sued in your capacity as a judge, correct?
Yes, no, that's correct.
So you agree. So my question is this: does it not create an anomaly that if I'm discharged from active service and I do something like that, on your interpretation, Section 47 does not apply? If I'm asked to come and act for 6 months, but I did this last year, for example, but they decide this is the time to issue summons, then they need to get the permission of the head of court.
Yes.
But they wouldn't need to get it if I'm a judge, but not acting. Doesn't that create sort of an absurdity that
Absolutely
you're
not.
dealing with someone who's no longer a judge, but is only a judge temporarily for a limited purpose, but then you need to get the permission of the head of court, even when it might not disrupt, because the head of court might say, well, the person is acting for 3 months. There's no way this case is going to come to court within 3 months, and if the purpose is not to disrupt, well, what's the point? What's the purpose then of 47 if it's only that?
Thank you.
Yeah.
Thank you very much for that question, Justice Kholopin. Here's the distinction. When you defame me somewhere in the village, then there are two distinctions. One is that you are not performing a judicial function in that context. When you are acting, the minute you come from that village to go and act, you are performing a judicial function. So that's the crucial difference. Secondly,
Understanding what the difference is, because the lawsuit relates to when you were in the village, not so.
yes,
And when you were in the village, you were a judge.
yes,
You were not performing your duties as a judge, but you were a judge in active service.
yes.
And 47, we agreed, applies there.
But it applies for a completely unrelated reason. I'll explain. That's what I was coming to. The second reason is this, and Mlambo JP made this point in Sola, which is the original case of Khampepe JP. The point was made that Section 47 does not only apply when you are performing judicial function. It also applied when you are being sued personally. So in your example of the village, I would be suing that judge personally. Here, none of those two gateway provisions apply, because the judge, the former judge that is being cited here, is neither being sued for judicial functions, nor is she being sued personally. She's being sued in her capacity in a third category called the chairperson of an administrative body, NO, nomine officio. When I'm suing your judge in the village, I will not say NO, because that is a different category altogether. And that's where part of the confusion actually is caused by this of saying, well, if it can go, which is really the nub of your question, if it can go beyond judicial functions, then what's your problem? But the question is, in which direction is it going? If it's going in the direction of personal suit, yes. But if it's in the direction of a non-judicial function and a non-personal function, let me put it that way, which is where we are, then the section doesn't apply. Thank you. Oh, yes. I've already apologized to the DCJ. We had promised to upload the finding of the JCC, which we did this morning, that we referred to in our heads. And we accept, before anybody says, that this is not binding precedent. It's being presented just as much as we would have presented an academic, albeit it was done by Justice Jafta and so on, but they were not performing judicial function, so to speak. But this is what they say at paragraph 29. A careful reading of the language, or the case lines is 006.1-122. They say, a careful reading of the language of Section 177 of the Constitution in the context of Section 174 and 176, that's a point I made earlier to Justice Mklanhla, reveals that the President appoints judges to the judicial office in all superior courts. And it goes with 176 and puts an emphasis on 176.2, which is the one that I did put. And then it says, judges of other courts, including the SCA, hold office until discharge from acting service in terms of legislation. Upon this discharge, the judges vacate office and retire. Very important. This is how Section 176 of the Constitution was interpreted in Seriti. The fact that a judge who vacates office in this manner retains the status of a judge does not mean that he or she continues to hold office. There is a clear distinction between that status and judicial office. This distinction was also clarified in Seriti. The status attached to the incumbent of judicial office, and when he or she vacates the office, he or she retains that status even while in retirement. But that status does not mean that the judge continues to hold office. On the contrary, he or she becomes a judge without office from the moment he or she vacates the office in terms of Section 176. As a result, he or she cannot exercise judicial power or function, if I may add, or perform judicial functions, or well, they've added themselves, unless reappointed back into office for a temporary period. But if he or she is guilty of gross misconduct or suffers from incapacity or is grossly incompetent, he or she would not qualify for reappointment, even if he or she would otherwise have been eligible. That second part obviously related to the facts. But the crux of what these justices were saying, albeit in a non-judicial capacity, was that that distinction has to be respected. As I say, again, in everyday language, a judge is a judge for life. We all know that. But they make the crucial distinction between that, for the purposes of payment and all that, and for the purposes of holding judicial office.
Good. Then finally, Mr. Mpofu, you're saying that we must interpret 47 to read that no civil proceedings by way of summons or notice of motion may be instituted against any judge of a superior court who holds office at the time, something to that effect, because we both agree that a judge who is retired is still a judge.
Of course.
And would, on a plain language, plain meaning of plain reading of this section, fit into it. And one would have to qualify it then by saying any judge who holds office at the time, either permanently or in an acting capacity, something like that.
Well, Justice Kolapen, I'm not asking for a miracle. I'm asking for you to do exactly what Justice Mlambo did in Mutata, which is to say, when he said, once retired judges are called back, then the section applies. That's really all we're asking for. And that, in simple legal language, simply means that it's not any old retired judge who's doing whatever, who's caught by the section. And Justice J.P. Mbenenge said exactly the same thing. And with the greatest respect, Justice Mlambo, in that case, did not differ with the formulation of Justice Mbenenge. He merely qualified it, and with respect, correctly, to say that to the extent that it doesn't apply, in other words, he was turning even the Mbenenge JP formulation to say you can't simply say, well, if you're retired, you're out. No, that can't be true. And that's not what we're arguing. Even if you are retired, if you're called back to perform a judicial function, then you are hit by the section. So we agree with the qualification made by Mlambo JP, as it then was, of the Mbenenge JP formulation.
Me? Mr. Mpofu, if we look at section 47.1, it seems to have broad application. And there's a specific exclusion of domestic violence matters.
Yes.
Now, leaving aside for a moment the purpose of the provision, on what textual basis can we exclude from its application any other proceedings against the judge, and where those proceedings originate from a commission of inquiry?
Yes. Okay. Firstly, the textual basis is on the use of the word against. The reason why the crafters of that section use the word against must have been, at least, or one of the purposes, to distinguish from situations where you are citing the judge, but the proceedings are not really against that judge. Remember again, and we go back to the Modiba J analogy. When you are applying for a recusal of a judge now, talking in a normal court, you are not exactly bringing anything against that judge. You are bringing an application for fairness, for lack of bias, for impartiality. It's not against that judge. That is why in the High Court you don't have to cite that judge. And even if the judge refuses to give my recusal, when I go to the SCA to then challenge that, I still don't have to cite the judge, because the matter has never been against that judge. It has been for the protection of impartiality. That's the first textual base. The second textual base, Justice Teron, is that the phrase, the head of that court, it would be an absurdity to the head of that court. What court? For a retired judge sitting in his farm somewhere there and doing their own thing, and then say the head of that court. As Justice Mlambo said, once that person is retired, excluding the situation of being called to act, they are no longer within the supervisory, I can't remember the actual phraseology, the supervisory jurisdiction or ambit of the head of the court. So who would be the head of that court? It would be an absurdity. Actually, that absurdity is playing itself in another case, but I don't want to let the cat out of the bag. But it comes this way, Justice Teron. If the person you are suing was the Chief Justice, for example, or a Chief Justice, then who's the head of that court? As I say, it's for the current case, it's not. So that's the second textual base. The third one is the one that Mudiba J pointed to, which is that recusal, for the purposes of this section, recusal applications, broadly speaking, are not civil proceedings. And she asked the rhetorical question. Again, this is the thing of applying after legal advice, so to speak. She says, if that was the case, then why was it not necessary to do a Section 47 application in the recusal application itself? And the last point which I want to make is this. In the case, again, today I'm seems to be supporting Mlambo JP's judgments. That's not for opportunistic purposes. But here's an example, Justice. If you go to the case of Corruption Watch and another versus Arms Procurement Commission and others, you will find in that case that the very same Justice Mlambo who would have been, who had made the other decisions, did not insist on a Section 47, which he could have done Meremoto, let's assume it was not raised, but let me explain the reason. The reason is found in paragraph 4 of that judgment. This is what Mlambo JP said. The first applicant is Corruption Watch, a non-profit company registered in accordance with the company laws of South Africa. Second applicant is Right to Know campaign, and so on. And here's the part. The first respondent is the Commission. The second respondent is Justice Willie Lehwabe Seriti, N.O., nomine officio, who is cited in his capacity as the chairperson of the Commission. That's exactly why we cited this respondent here in the same way. And then he says, the third respondent is former Judge President Hendrik Tekiso Musi, N.O., who is cited in his capacity as a member of the Commission. The fourth respondent is the Minister of Justice, and so on. And then it goes on. I admit that the issue was not squarely raised in that matter, but I venture to say that the reason why this citation, which is a mirror image of the citation that is used in this case, was not subjected to a Section 47 permission requirement, is exactly the fact that those judges were cited A, nomina officio, and B, in their capacity as chairpersons of a commission, which is the same as this one.
Mr. Mpofu, apart from the minority judgment of Justice Mudiba,
Yes.
what other authority do you have that these are not civil proceedings for the recusal? Civil proceedings as used, as that phrase is used in Section 47(1).
Well, the authority is, firstly, even Justice Mudiba, who makes this proposition, accepts that in form it is. All she says is that form should not be elevated over substance. So that qualification is very important. So nobody, neither me or Justice Mudiba, even worse, would come and say, and that's why I answered the question candidly to Justice Mhlanhla. Are review proceedings civil proceedings without more? Yes, of course they are. Everyone knows that. But the point is, in the context of this, are these proceedings in substance, not recusal proceedings like any other recusal proceedings. That's the point that really Justice Mutiba is making. I'm quite sure she's not making the absurd point that putting a notice of motion and going into court to do review application is suddenly not a civil process. But if it is it against? And that's the point I'm making. And we venture to say, no, it's not against anyone. And,
So we can accept that there are civil proceedings as envisaged in section 47?
No.
We
no,
can't?
No. We can accept that there
I'm
are
confused,
civil-
Mr. Mpofu.
Well,
Either
you shouldn't be.
the argument is that they are not civil proceedings as envisaged in 47, or they are.
No. Okay, let me put it out. There is such a thing
Because against comes afterwards.
yes. But
So they could be civil proceedings, but on your argument, they are not against the judge, if I follow you.
no, that's not what I'm saying.
Or
I'm
are you saying they're not civil proceedings and they're not against the judge?
I'm not saying that either. I'm saying they are not civil proceedings for the purposes of Section 47. That's all that Mutiba J found. That recusal proceedings.
Now, this is my question.
Yes.
If your submission is that they are not civil proceedings as envisaged in
In
Section
Section
47,
yes.
apart from the judgment of Modiba J, where is your authority for that proposition?
Well, the authority, as I've said earlier, is based on the common knowledge that all the judges sitting here have, that in recusal proceedings, you do not have to cite the judge. And that's the point that she makes, number one. Number two, that she says the technicality, and you may or may not agree that it's a technicality, but she says that the technicality that if you are aggrieved by that decision, excuse me, in the case of a judge sitting in court, you would appeal in the SCA, and in this case you would review them. Is neither here nor there. That's what she says, and we agree with that formulation. So she's not saying, as I say, it would be absurd for her to hear, and I'm sure she's not saying that bringing review proceedings is not simplicity civil proceedings. But that's not the question you are required to ask. The question you are required to ask is like saying a judge. Is she a judge? Yes, she's a judge. But is she a judge for the purposes of Section 47 as envisaged in Section 47 with the purpose? Because we can't put aside the purpose with respect, with the purpose and all that. And it might well be that for a particular purpose, as explained by the JCC, the person is a judge for life. We all accept that. But the question is whether they, once they are retired and they are doing something unrelated to judicial functions, they are hit by this section. Thank you.
Now, this is something you didn't address in your argument, Mr. Mpofu. Did the chairperson have to decide the recusal application with other commissioners, or does the rules of the commission, or the commission's rules allow her to have decided that by herself?
Thank you. I did address this in my 30 minutes. Well, I called it the ultra-virus point, but maybe I should just call it the improperly constituted body, which is the same thing. Thank you, Justice Teron. The chairperson cannot have it both ways, with the greatest respect. The chairperson, as I said, is cited as the chairperson of the commission, right? In other words, she's the symbolic representation of the commission, number one. That can never mean that she is now isolated as a human being. And proof of that, Justice Teron, is the fact that when on the 16th of January this year, we went to argue the recusal application, she sat in a panel with the other two commissioners. If she thought this was just about her, what were they doing there? They were...
No, I don't want to interrupt you, Mr. Mpofu, but can you answer my question legally, please? Like with reference to the rules, with reference to the law, was she entitled to make the ruling by herself? We really want to know what perhaps was in her mind. Can you contend and
Okay.
refer us to this rule or
Yes,
this case
I
to
will.
say she had the power
I will.
to make that ruling by
Yes.
herself? And it seems to be common cause, and please correct me if I'm wrong, that she decided the application alone. Is that common cause between the parties?
Yes, it is. But unfortunately, the question has to be answered in the manner that we have presented the problem. And it is the following, Justice. Let me start with the rules so that we get that out of the way. The reliance is put on Rule 3 when the application was brought in terms of Rule 11. And the application is made to the Commission, right? And how do we know that? Because, sorry. I'm sorry, Judge. We know that because sorry, Justice. If you go to 011672, okay, well, let's take it a step before. You remember that the affidavit of Semenya SC, which we say should be read as pronoun scripto, is purportedly done as an affidavit of the Commission in the first place. And so it says sorry, I just want to go to, let's start at 746, or 746. Sorry, Justice. 746. Yes, I think this makes it much easier because this is on the pen of Justice of Khampepe herself. These are the directives that she gave us in terms of Rule 3.3. No, she says notice in terms of Rule 3.3, Jacob Zuma, that was just a heading because that's her application. Then she says, in response to your letter, 3rd December, requesting that I be recused for reasons outlined in your letter, the Commission deems it fit in the interest of time available for the Commission to discharge its work to consider your client's request through the following directives. So it's the Commission. And then just run to 1.1. Your client is directed to file his application for my recusal to the Commission.
Mr. Mpofu, once again, I don't want to understand the attitude of the chairperson or the Commission. I want to understand what the rules say and what the law says.
The law. Okay, let's start there. Maybe it will make it easier. The SARFU, the case of SARFU, makes it clear, which we've cited in our heads, that when the recusal of a member of a panel is called for, that panel collectively, individually first, and collectively must make that decision. Why is that so? It is so for a very important reason, Justice Teron. Because we can never be in a situation which we are in now, where neither ourselves nor your esteemed selves know whether the other two commissioners agreed or disagreed with the finding. SARFU says it's not only our rights that are violated, but the rights of the other two commissioners. Because those commissioners have a right themselves to say, if these are the facts, we do not want to sit with you. And that's what SARFU says. SARFU says, so it's not just a question of just sitting there as a collective and taking collective decision. No, it is because the majority of the commission could possibly have upheld our application. So we don't know. The majority is excluded. What kind of procedure how can that in any law, anywhere, be a situation where, let's say it's a panel of 3 judges in a full court, and then you just hear one person, and you don't know what the other 2 judges' view is on the matter. Simply because, even though they sat in the recusal application, let's say it was this panel, and one is asking for a recusal of one of the judges. The rest of the panel, even though the recusal is not directed at them, according to the SARFU, the Constitutional Court precedent in SARFU, is entitled A, to sit for obvious reasons, but B, to decide. And it may decide against that one. That one judge who's the target of my recusal application might think that I don't agree with Mr. Mpofu. But if the panel agrees, then they will succeed. In this case, the process was illegal in the sense that the body or the person who took the decision, the commission was improperly constituted, to put it in normal language.
The respondents point to a number of rules
Yes.
of the commission that allows a chair to decide interlocutory applications on her own.
Yes.
Why is this different? It is an interlocutory application, isn't it?
No, it's not an interlocutory application, with the greatest respect. This application goes to the root of the very existence and composition of this whole business. The terms of reference, remember the terms of reference of the president says, I, President Ramaphosa, hereby constitute something called the commission. That commission is made up of Commissioner A, Commissioner B, and Commissioner C. So the thing called the commission is a collective of those persons. That's the first point. The second, so it's not an interlocutory application with respect. But surely, if that was the case, then why is it that in the other recusal application of Seminya SC, the commission gave a ruling? It did. And all of a sudden, in this recusal application, it says I. And you can read it through. It no longer says the commission finds this or that. It's now I.
I'm still trying to understand why it's not an interlocutory application. What application would you then refer to it as? And let me ask 2 questions together.
Yes.
Do you agree that there are interlocutory applications that the chair can decide on her own?
Of course, in terms of the rules, yes.
Why was this not an interlocutory application?
Okay.
It's brought during the life of the commission as an application.
No. Yes. Not every application that is brought during the life of proceedings is an interlocutory application. Interlocutory, in this sense, is in the okay, that's another statute, section 18. I won't go there. This application is fatal and abortive to the very existence of the foundation of the commission as presently constituted, or as will ever be constituted.
That on its own wouldn't make it that it doesn't qualify as interlocutory. How many other interlocutory applications are not fatal to main proceedings, but they still in their nature are interlocutory proceedings?
Yes, interlocutory proceedings, as said in Rule 611, if we want to go to the specifics. Rule 611 of the Rules of Court tells us what interlocutory proceedings are. And those are the proceedings that are brought in the short form, not in the normal long form application. And because they are ancillary to the, in other words, they're not totally defeating to the cause. Remember, the cause, the causa of the actual proceedings stands. But to bring interlocutory application, like our Rule 53(1)(b) application, that's an interlocutory application. Why? Because it simply says you must discover in the main cause. But if we were bringing an application that says you are in the wrong court, you should have sued me in Durban, you are now suing me in Cape Town, that cannot be described as an interlocutory application. That's an application that goes to the root of the very existence of that causa. So, but if I'm saying, okay, you're suing me in Durban, but you did not serve me after the 10 days or whatever, that's an interlocutory application. So in the context of proceedings such as these, to say that proceedings which basically abolish the entire body are interlocutory to that very body is with the greatest respect.
Can an interlocutory application have a substantive outcome?
Of course, it can, but it doesn't mean
Isn't that what would happen here?
No, Justice Theron, the fact that an interlocutory application can have logic doesn't work like that. The fact that an interlocutory application can have a substantive application doesn't mean every application that has a substantive application is therefore an interlocutory application. It can be.
I'm asking you to break it down for me, Mr.
Yes,
Mpofu.
okay, let me break it down. If A is equal to B, in other words, it's possible, as you say, can. That means possible. Is it possible for an interlocutory application to serve substantive outcomes? Yes. But does that mean every time there's something that has a substantive outcome, it therefore is an interlocutory application? No. So that's in logic, it's a syllogism. So it doesn't, the one thing doesn't apply both ways. So if I say a car is a vehicle, it doesn't mean every vehicle is a car.
I'd be putting it mildly if I didn't say I was confused. My last question. Why should this court be a court of first and last instance on the merits of the recusal application?
Right.
This court is very, very reluctant to do so. We do so in rare and exceptional circumstances.
Yes, thank you, Justice. Yes, that's the question I think Justice Majid had posed. Well, the shorthand is really what I presented in my 30 minutes, which is that this case is, for the reasons I articulated already, a much better case than the Ramakatsa case, which was heard by this court as a court of first instance. And the reason is that that case was heard is what is articulated, I think, in paragraph 16 of that case, which was that to do otherwise would have been to allow a devastating illegality to visit South Africa. So here, ironically, the respondents themselves make our case. What do they say? Court, this matter involves the most egregious matter of the non-prosecution of apartheid atrocities of people who committed heinous crimes. It involves victims, sorely so, who have waited for decades for justice. And it is not in the interest of justice to make them to wait any longer. And we say we agree because to prolong the pain of the victims, let alone the potential implicated persons who might face all these other calamities, like going to jail, as we know, if they don't honor the subpoenas. In the case of Mr. Mainecha, he will tell you the risk, what we have posed as a risk, has actually materialized in their case, because they've now been served with a subpoena for President Mbeki to appear, and they had to go to Asian court and all that. We have not, but that's proof of the enormity of this matter. So, in which world would a court allow down the road a patent illegality of a commission, so-called, that is going to investigate to nowhere, which is plainly illegal, chaired by a person that we should not be chairing it, millions of rands later, after we've traveled all these roads back to the High Court of SCA and so on, while the millions are rolling, and then one day, in 2 years' time, it's found that, no, that was a nullity. So that's even worse, as we say, than the possible calamity which would have befallen the citizenry in Ramakata. Because the Truth and Reconciliation Commission cases is something that affects this, it's the foundation, as they say themselves, the foundation of this very democracy was based on this granting of amnesty or the refusal thereof. So this is a case that it would be a travesty, with the greatest respect, or let me put it positively, it is in the interest of justice, blatantly, that the merits should be dealt with. Secondly, as I've said, there's already the wisdom of so many other courts, and the merits have been dealt with by the minority judgment, unlike in Ramakata.
Thank you, Mr. Mpofu. Thank you, Deputy Chief Justice.
Advocate Mpofu, we've long gone past our break time, but we insist on taking it now. The court is going to adjourn
Yes, the court, please.
for 20 minutes.
Thank you. Oh, yes. Yes. Oh, these are the rules. What is the submission? Also not. Oh, sorry. Yeah. Actually, I wanted to ask you.
So let me assist you. Give me the rules, let me assist you.
Yeah.
So if we go here, it says
Yeah.
And then 3.3.7, it says,
of Ramakatsa, the court, and I will not read. So which political right you are under really doesn't matter. The issue is that, as you correctly point out, there must be that political right, or I'm sorry, that fundamental right, and more. And now, so to answer your question specifically, the more is not whether is this right or that right. The more is what was articulated by this court in. When we come to the merits, the court might differ with that. So that's why the court said, if what you are saying is true, if indeed there are these misconducts, if there is this egregious breach of the rule against bias, if there's all the the breaches of Section 34 and NEMO UDEX and all that, if all that is true, what are